Imagine a nonprofit organization that has served its community for years, building up valuable resources and property. What happens to all of that dedicated effort and investment if its mission eventually comes to a close? It is a crucial question for anyone involved in the nonprofit sector. When a nonprofit organization officially dissolves, its assets do not revert to its founders, directors, or any private individuals. Instead, these assets must be distributed to another qualified tax-exempt organization that shares a similar charitable or public purpose. This fundamental rule stems from the very nature of a nonprofit's tax-exempt status, particularly for those recognized under Internal Revenue Code Section 501(c)(3). The Internal Revenue Service, or IRS, requires that a nonprofit's assets be permanently dedicated to a public benefit. This is often referred to as the dedication clause. Should the organization cease to exist, these assets cannot unjustly enrich private individuals but must continue to serve the public good through another qualified entity. State laws also play a significant role, often dictating the specific procedures for dissolution and asset distribution, ensuring compliance with charitable trust principles. To navigate this process correctly, your organization should first carefully review its original organizing documents, such as the Articles of Incorporation or bylaws. These documents often specify procedures for asset distribution upon dissolution. Next, develop a detailed dissolution plan outlining all liabilities, remaining assets, and proposed recipient organizations. It is important to identify recipient organizations that have a similar exempt purpose to your dissolving entity. Finally, obtain any necessary approvals from your state's Attorney General or charity regulator, which is a common requirement to ensure proper oversight of charitable assets. Proper preparation prevents future complications. Understanding the dedication clause is vital because it underlines the core public trust inherent in tax-exempt status. This clause is a non-negotiable requirement for maintaining 501(c)(3) status and ensures that the public's investment in the nonprofit continues its intended purpose. Ignoring these rules can lead to severe penalties, including revocation of tax-exempt status retroactively and potential personal liability for directors. Therefore, seeking advice from a qualified legal professional specializing in nonprofit law is an essential step to ensure a smooth and compliant dissolution. Properly distributing a nonprofit's assets upon dissolution safeguards its legacy, honors its original mission, and upholds the public's trust in charitable endeavors. By following established legal and regulatory guidelines, you ensure that the organization's resources continue to contribute to the greater good, reinforcing the very foundation of nonprofit service.